So now let us move to our first panel, which will focus on recent developments in commercial investor-state arbitration in the CIS region. And the first speaker is Sargis Grigoryan, who is a senior and well-known practitioner doing both commercial arbitration cases and investor-state arbitration cases, also some high-level political cases, as I know. And Sargis has a PowerPoint presentation, and he will also touch upon the recent Nagorno-Karabakh conflict and its implications for dispute resolution. Sargis, the floor is yours.
Hello, everyone. Thank you for having me. And it's my pleasure to speak to you today. And I'll be covering a developing topic. It's about the protection of investments in armed conflicts, particularly after the 2020 Nagorno-Karabakh war. This topic as a legal issue is extremely important, not only because it is the second case after Crimea, but also it can shed new light on various unexplored issues in international investment law. Currently, our team is assessing the possibility to bring investment claims against Azerbaijan. Of course, we are also examining the recent developments in Crimea-related arbitrations. Finally, I constructed my presentation as a case scenario, some sort of case study, in order to be productive for our attendees. However, I will not cover any policy matters or developments. By the way, I have inserted some paintings of Martyro Saryan in my presentation, an Armenian painter who was born in Rostov, Russia. Yeah, let me put forward this roadmap. And firstly, I'll briefly present the facts of that devastating war, which has changed not only the entire region, but also the CIS region. Then I'll talk about the legal status of Nagorno-Karabakh. And thirdly, I will also present the ongoing and future legal proceedings, as well as I will discuss the possibility of investment claims arising out of Azerbaijan military actions in Nagorno-Karabakh. I will also present several types of clauses enshrined in Azerbaijan bilateral investment treaty, which deal with violent situations, including armed conflict. Finally, I will explore some issues related to exceptional defenses. Facts of the war. Yes. So the escalation started at the end of September last year, 2020, and the full-scale war lasted for 44 days, which brought over 5,000 deaths. In the beginning of November, Armenia, Azerbaijan, and Russia signed a declaration to end military conflict. This war has damaged and destroyed the major infrastructure, for example, the provision of water, electricity, social infrastructure. Azerbaijan deliberately targeted both civilians and civilian infrastructures in Nagorno-Karabakh, and the total amount of damages of Nagorno-Karabakh is over 1.5 billion. And it's about the $2 billion. And this valuation is preliminary, and it's still ongoing. The next issue is important. It's about the status of Nagorno-Karabakh. So it is a disputed territory, internationally recognized as part of Azerbaijan, but most of it is governed by the unrecognized Republic of Artsakh. Importantly, Artsakh has certain attributes of statehood under international law: territory, population, and government. However, the final one, which is the recognition by other states, still remains unsecured, unsuccessful. Having said that, the entire investment protection regime of Azerbaijan directly applies to the territory of Nagorno-Karabakh, and here Azerbaijan has 52 bilateral investment treaties and a law on investment activity. Finally, Artsakh hosted foreign investors from the US, UK, Switzerland, Lebanon, Germany, and other EU member states who suffered substantive damages and losses due to Azerbaijan's military actions. Let's come to two different forums. And until now, Armenia has launched over 12 interstate proceedings against Azerbaijan and Turkey at the European Court of Human Rights. Currently, Armenia is encouraging foreign investors to commence investment arbitration proceedings against Azerbaijan directly under various bilateral investment treaties. And currently we are advising the government to commence a dispute settlement mechanism under Article 27 of the Energy Charter Treaty, which provides for an arbitration regarding the interpretation or application of the treaty. Here, there is an opportunity for Armenia, for those investors to submit a claim by seeking a declaration that Azerbaijan's military actions were not in compliance with the Energy Charter Treaty. It means Armenia does not need to identify particular investors that have been harmed by Azerbaijan's military actions. Yeah, sorry. Yeah. Now, let's come to key legal issues. Having considered time constraint, I will now briefly discuss the key legal issues, which are crucial in order to bring investment claims against Azerbaijan. The first step is in determining whether investor may enjoy investment treaty protection is to identify whether there is an applicable bilateral investment treaty in force. For example, between Armenia and Azerbaijan and the investor state. In our case, Germany. And there is one bilateral investment treaty signed between Azerbaijan and Germany in 1995. Then, where there is a potential applicable bilateral investment treaty, the next issue is whether it entitles a particular investor to protection as a national of a state party. Most bilateral investment treaties draw a distinction between two categories which are entitled to enjoy protection of the treaty: individuals and companies and other judicial entities. Then, for a qualifying investor to rely on the substantive protections and procedural safeguards in Azerbaijan's bilateral investment treaties, it must have made an investment which is protected by the treaty. Most BITs define the term investment in a broad, open-ended way that ensures a high degree of flexibility in application. It's also important to meet a territorial requirement which is enshrined in Azerbaijan's BITs. For example, Germany-Azerbaijan BIT defines investments as every kind of investment in the territory of one party, owned or controlled directly or indirectly by nationals or companies of the other party. The next point is that those standards are vary considerably in precise scope and content. However, there are common categories of protections, many of which are derived from the principles of customary international law on protection of alien. For example, fair equitable treatment, full protection and security, national treatment, and etc. In addition to substantive protections, BIT set out a variety of dispute resolution procedures and conditions, and that the claimants must review these sections of applicable BIT as soon as possible. I do mean cooling off period or fork in the road provision. Applicable standards. Here, let me generally say that Azerbaijan's bilateral investment treaties contain various standards of protection. These standards are, again, fair equitable treatment, full protection, protection against arbitrary treatment, national treatment, MFN, and etc. Some tribunals in practice have regarded some of these standards as being closely interrelated. However, there are two clauses which are crucial so as to be able to sue Azerbaijan for its military actions in Nagorno-Karabakh. These are full protection and security and war clauses, which I will further elaborate in my presentation. However, let me say a couple of things about fair and equitable treatment, which is the most invoked standard in investment treaty arbitration. It protects investors against serious instances of arbitrary or abusive conduct by host states. Some Azerbaijan's bilateral investment treaties use the unqualified form of the fair equitable treatment standard and link it with the standard of full protection and security in the same clause. Let's now come to the non-binding standards applicable in conflict. For example, in considering the application of human rights, the classic human rights paradigm focuses on a state duty to exercise due diligence to protect against human rights violations. Full protection and security standard is one of the key standards, and which is also available in Azerbaijan's bilateral investment treaties. Many of these treaties refer to full protection and security. And as you know, the Energy Standard Treaty refers to most constant protection and security. There is no doubt that this provision is designed to protect investors and investments against violent actions. The arbitration case law is very clear that this standard applies essentially when the foreign investment has been affected by physical violence. It means that Azerbaijan promised in its bilateral investment treaties to take the necessary measures to protect the investments against adverse action by state organs, i.e. by its militaries. However, we need to state that this standard does not create strict liability, but an obligation of due diligence. It's also important to mention that the full protection and security standard applies in conjunction with international humanitarian law, which provides that attacks shall be directed only against military objects or persons. Even when a lawful attack is launched, international humanitarian law placed further restraints on Azerbaijan to take precautionary measures in order to avoid or to minimize the collateral effects of hostilities on civilian objects.
I guess you have 1 minute to conclude.
Yeah, all right. And my next slide is about the war clauses, and here I'm discussing about the non-discrimination war clauses, extended war clauses, and strict liability war clauses. Here, just I'll discuss about BITs, which contain war clauses that impose a form of strict liability, i.e. they impose an absolute obligation to compensate damage from war, irrespective of whether the loss was caused by armed forces or by other subject. And finally, exceptional defenses, which are available in Azerbaijan's bilateral investment treaties, so-called security clauses. If the security exception applies, the investor is deprived of bilateral investment treaties protection. This would also include reliance on the treaty full protection and security standard. I think I've finished. Thank you very much, Yarik.
So the next speaker is from Kazakhstan, Bakhyt Tukulov. He is with Tukulov and Kassilgov litigation in Almaty. And Bakhyt's primary expertise is in the area of commercial arbitration and commercial litigation. He is one of top Kazakhstani lawyers recognized in various reference books and guides. Bakhyt will give us an introduction to the Kazakhstani system of dispute resolution when it comes to arbitration, and he will also he may have some updates from Kazakhstan, from his jurisdiction. Bakhyt, do you have slides or not?
I don't have slides.
Okay.
Sorry about that.
No.
Thank you, Professor Kryvoi, for this opportunity to speak today, and I thank everyone for this opportunity to speak. As you correctly pointed out, my main practice concerns with commercial arbitration and litigation. We do not have much exposure to investment treaty arbitration. although we would like to work on this at a later stage. But I will nevertheless briefly give an outline of what we know about investment treaty arbitrations involving Kazakhstan. But as Beju is attending the seminar, I think he will give you much more information about the insights of arbitrations involving Kazakhstan. Kazakhstan has signed and ratified over 50 BITs so far. Latest two bilateral investment treaties, of which we're aware, which have been signed, are with Singapore and UAE. That was in late 2017. Since then, we haven't heard of any new bilateral investment treaties being signed. And these two bilateral investment treaties with Singapore and UAE, as we understand, are not yet in force. As the previous speaker has pointed out, the previous one, Professor Kryvoi has pointed out, there have been 24 investment treaty arbitrations involving Kazakhstan. As far as we know, as of 2020, 4 cases are listed, are publicly known. 2 cases are Big Sky and Windor, which are pending, and 1 case is settled, which is Da Vinci, and one rendered, which is Algambra. As well, although we are not much involved in investment treaty arbitrations, but I have had exposure to a few claims which led to investment treaty arbitration when at the litigation stage. So most of these claims have faced serious commercial or maybe public litigation in Kazakhstan. And for example, Big Sky, I was involved in this case when all of the activities from the part of Kazakh state authorities took place. So I know a little bit of the internal background. So based on our experience on the ground, and based on what I know from investment treaty arbitrations, the general line is that at least several cases occurred by way of previous owners of a share in a Kazakh company, by basically them filing a claim to invalidate a sale and purchase agreement with the use of Kazakh state courts. For example, in the Rumeli case, which Beju mentioned, as far as I understand the case, as far as I recall the case, basically shareholders filed a claim that a foreign investor breached Kazakh limited liability partnership law by importing some old, outdated equipment. And with the use of Kazakh judicial system, they were able to execute a forced buyout of the share for a compensation which was way too less than the actual value. And within a year or so following that forced purchase of the share was sold to a Russian investor, and Beeline basically purchased it for more than $350 million, as far as I recall. And this same and another scenario which I mentioned, invalidity of the transaction, for example, was in a few other cases. But the interesting case about, for example, the Windor is that there was an investor, as I understand, obtained basically, well, it's somewhat unusual, but investor here is a party which obtained an arbitral award, a commercial arbitral award against a commercial Kazakh company, and the claim being pursued on the basis that Kazakh government, Kazakh judicial system refused to recognize and enforce a foreign commercial arbitral award. So this case stands apart from usually usual cases which Kazakhstan faces. In the Algambra case, as I understand, Kazakh state authorities rejected, basically withdrawn a contract based on allegations that a subsoil use contract was not properly performed. In the case involving in the Big Sky case, as I understand, also the previous shareholders brought a claim to invalidate the share sale and purchase agreement on the basis that some consents were not obtained, as far as I recall. Basically they returned their share back and did not provide sufficient compensation. So, and BIICL also mentioned that there was one case in which we were indirectly involved, where under Kazakh law, for example, if a transaction, a share sale and purchase transaction is invalidated, as like in Russian law, I guess, in other legal systems as well, if a transaction is invalidated, each party which received valuables from the transaction needs to return it. But because payments are made through unrelated entities, through, say, offshore jurisdictions, when a transaction is invalid, for example, a share sale and purchase agreement or a contract for the purchase of a subsurface use right, then the party which basically sold the subsoil use contract cannot act as a party which is supposed to return the money received under the transaction. So, we saw a case where the party which purchased a subsoil use contract was incapable of claiming the money back, which it paid for the subsurface contract. In relation to hold on. In relation to the general commercial arbitration framework, as you probably heard, we have the notion of Astana International Financial Center in our country, which basically is an attempt to create an analog to Dubai International Financial Center, basically to create a jurisdiction within Kazakhstan which would apply its own legal regime based on the principles of English law. So it's not a direct application of English law, but an application of rules based on principles of English law. And those acts are available on the website of AIFC Court. The main feature of AIFC Court and main way in which, if you, for example, submit to International Arbitration Court with the Astana International Financial Center, is that you are not you do not pass recognition and enforcement procedures through Kazakh state courts. So, for example, in the case of commercial commercial arbitral award, for example, LCIA, you would have to go to a Kazakh state court and you would face the risk of rejection on whatever basis. And the larger the amount of the claim is, the higher likelihood that the Kazakh court would probably be influenced by corruption or by other consideration would reject. So in the case of Astana International Financial Court, all of the arbitral awards rendered by the International Arbitration Court of the AIFC would exclusively pass through the AIFC Court. So because AIFC Court is employs former ex-judges of from England and other jurisdictions, similar jurisdictions, there is higher likelihood that AIFC Court would uphold and would recognize and enforce an award issued by the International Arbitration Court of AIFC, an International Arbitration Center of AIFC. And this sort of allows to improve the chances for successful recovery and successful recognition enforcement. We have, in order to submit to AIFC Court, for example, or International Arbitration Court at the AIFC, you simply need to sign their agreement and you have the right to opt in. There's no need to seek to have a link to AIFC. We have done some research on the statistics of successful enforcement of arbitral awards by the Kazakh judicial system, and our statistics, which does not tend to be absolutely reliable, suggests that Kazakh courts generally, by number, recognize and enforce approximately 86% of foreign arbitral awards. But that 14% which gets rejected tends to include larger amounts. So the general trend is that the vast majority of foreign arbitral awards are recognized and enforced in Kazakhstan, and the situation has changed seriously in the past 10 years. But the larger the amount of the claim, the higher the likelihood that there could be corruption or otherwise influence. So this is something which should be borne in mind, and this, as I mentioned, could be mitigated to some extent by submitting the dispute to International Arbitration Center at the AIFC Court. Kazakhstan is a party to two conventions, 1958 New York Convention and 1961 European Convention. Both conventions worked directly, although there are some serious differences between the law which Kazakh courts apply, the Civil Procedure Code, and the conventions. Conventions have direct effect, and we haven't heard any serious issues with enforcement apart from those which I mentioned. General arbitration law our arbitration law is based on UNCITRAL model law. There are no serious differences with the model law. Arbitration domestically works well, except for the main risk that arbitral awards issued by domestic arbitral tribunals can get set aside in various unexpected situations. You need to obtain a consent from the state to enter into arbitration agreements when it comes to disputes involving the state and state-related entities. There are some weird things like opportunity to reconsider an arbitral award on the basis of newly discovered circumstances, mostly referring to criminal acts. And also one of the main differences between the New York Convention and the local law is that a New York Convention, Article 5, for example, provides for a court, for a freedom for a court to refuse recognition and enforcement in the case of circumstances stated in Article 5, while Kazakh law obligates a judge to refuse recognition and enforcement in the case of those in the case of those situations mentioned in Article 5. So one should be careful about choosing arbitration institution in Kazakhstan. One of the positive features is that when you obtain a foreign arbitral award and seek recognition and enforcement in Kazakhstan, and if a Kazakh court issues a ruling to recognize and enforce a foreign arbitral award, that ruling becomes binding immediately and can be enforced immediately, even if it is appealed further. We have seen a number of cases when foreign parties were able to quickly obtain a foreign arbitral award and have it enforced before it was further appealed. So this is a good chance for foreign parties to obtain recovery from Kazakhstan. So basically, this is briefly on Kazakhstan. If you have questions, I'm ready to answer.
Thank you very much, Bakhyt, for this overview. And we're now moving to the next presentation. The next speaker is Konstantin Kroll from Dentons. He's a partner at the firm's international arbitration practice and also the head of Russian corporate and M&A practice. What is quite unusual about Konstantin's background is that he is a triple qualified as a Russian advocate, solicitor of senior courts of England and Wales, as well as Irish solicitor, non-practicing. Konstantin, do you have a PowerPoint presentation or not?
Yarik, thank you very much for this introduction. I will not have the slides. Well, I'd like to start thanking again Yarik and Dmitry and other organizers for organizing this wonderful and important event. Also, I'd like to start, I couldn't but reflect shortly on a wonderful presentation by colleague Vasani, because I think it was very thought-provoking. I just like to contribute one thought which might be of assistance to colleagues Vasani's PhD, is that I agree with Vajro that even though I at Moscow State University studied division of powers and systems of checks of balances as the proper way of implementation of parliamentary democracy, but I always felt that it's not deeply rooted in the history of Russia. And I would just like to add that I don't think it's just the Soviet past, it's also pre-Soviet period, because Russian Empire was an absolute monarchy. It was never a constitutional monarchy, and therefore that absolute monarchy then switched to the Soviet period, and therefore there is no deep background of system of checks and balances, and therefore probably to better understand the way of thinking of various officials in this country and other countries of the former USSR. And I would recommend not to compare Russia to the Western democracies, but maybe look at China, for example, and look how they approach these issues. And then you may well find a lot of similarities. And that could be a sort of way forward to understand this better. But anyway, so after this little detour, I'd like to go back to the subject of my presentation, which of course recent developments in Russia. And I'd like to start with the most recent development, as recent as last week. And I'm very glad to report that we have some good news for a difference. And the news are that two prominent and reputable international arbitration institutions, the ICC Court, International Chamber of Commerce Court of Arbitration, and Singapore International Arbitration Center, were accredited by the Russian Ministry of Justice and granted the status of so-called permanent arbitral institutions for Russian law purposes. What it means is that these two arbitral institutions will now be able to administer arbitrations on the territory of the Russian Federation. And why it is important is that, as a matter of Russian law, certain types of disputes are only arbitrable if there are arbitrators on the territory of the Russian Federation. And in particular, corporate disputes fall within this category. Which means that now ICC Court and CIAC can administer corporate disputes on the territory of Russian Federation, and this is very important. So until last week, there were only two international arbitral institutions which were regarded as permanent arbitral institutions for Russian law purposes, and these were the Hong Kong International Arbitration Center and Vienna International Arbitration Center. And now there are four. And I think this is very positive development, and I'm very glad to report this news. The other important fact that I'm going to share with you is less recent and less positive, I'm afraid. And this is the changes introduced to the Russian arbitrage procedure code. And arbitrage, we use this term for state commercial courts. So these changes relate to the amendments introduced to the arbitrage procedure code, which now grant Russian state courts exclusive jurisdiction over disputes involving sanctioned entities. And as you might have come across, that sanctions do impact international arbitration in various ways, and very often a sanctioned party has problems instructing legal counsel, has problem paying fees, whether arbitration fees, fees of legal counsel, fees of experts. So it can be quite sort of problematic. And the Russian lawmaker decided to somehow protect the parties affected by the sanctions. So these are not just Russian parties, these are any parties involving non-Russian which are impacted by the Russia-related sanctions. And if a party can prove that its access to justice in a non-Russian jurisdiction is limited because of the sanctions, then not just that the Russian courts have a jurisdiction over such dispute, Russian courts are now able to grant an anti-suit injunction to prevent a non-Russian party to proceed with arbitration outside of Russia, irrespective of the arbitration clause. So this is a very interesting development, because historically, both in the doctrine of Russian law and in practice, Russian law never recognized anti-suit injunctions as an institute. And that's not unique just to Russia. It is not uncommon for civil law, continental law jurisdictions generally, because we tend to follow old Latin principle of parum non habet imperio. And it's sort of contrary to our way of thinking that a court in a foreign jurisdiction can impose any restriction on a national sovereign court. Nevertheless, in the context of this sort of sanctions situation, Russian lawmaker granted Russian courts the right to impose anti-suit injunctions. And of course, you ask me, so are these anti-suit injunctions going to be enforceable outside of Russia? And the answer is most probably not, and certainly neither in the UK nor in most other Western jurisdictions. These Russian anti-suit injunctions are not going to be enforced because courts abroad are going to look at this situation from the pro-arbitration stance. Having said that, Russia does have bilateral agreements on legal assistance with certain jurisdictions. So in theory, if a Russian court grants an anti-suit injunction, in theory, that injunction could be enforced in certain jurisdictions which have treaties with Russia on mutual enforcement. And of course, it's important to bear in mind that if a party fails to follow the injunction granted by the Russian court may impose a penalty in favor of the sanctioned party. Actually, it will be paid in favor of the sanctioned party, and the amount of the penalty is up to the entire amount in dispute. So this is another sort of worrying aspect, because as we all know, very often the claim in the dispute may be inflated because the party may claim more, expecting to recover less. But of course, the penalty may be in the entire amount in the dispute. It's not linked to the ultimate final reward. And again, of course, this penalty will most probably not be enforceable outside of Russia. Having said that, if a party who was penalized has any assets in Russia, these assets might be at risk. So I'm not going into details of what court practice has already emerged on that, because I believe this will be subject of tomorrow's panel on these issues. But I would encourage you to attend tomorrow's session, because this practice is extremely interesting and controversial and self-contradictory. So again, this is something to watch out. But generally, what I would say is that all these sanctions-related issues, even before the changes to the Russian law that I have just mentioned, all of this has led to change of pattern of parties' behavior when choosing the forum for dispute resolution. So whereas before, London and the LCIA was almost the default position for the parties to choose as the most popular forum for Russia-related disputes, we see an emerging trend of parties opting for arbitration in Asia, in particular in Hong Kong and in Singapore. And this is driven by the fact that neither Singapore nor Hong Kong have adopted any Russia-related sanctions. And of course, they present parties a very solid forum, very reputable, and which policy is comparable to London. And of course, the fact that SIAC and HKIC are both recognized by the Russian Ministry of Justice as the permanent arbitral institutions, that fact gives parties additional comfort that the awards granted by these institutions are more likely to be enforceable in Russia. Because again, historically, as I think a lot of our participants know, there have been issues with enforceability of foreign arbitral awards in Russia, and Russian courts tend to rather broadly apply the principle of contradiction to public policy, which is not narrowly defined in Russian law doctrine. And even though, again, in theory, there are there is a guidance from the high courts in this country as to that the public policy should not be interpreted too broadly. In fact, and I think, again, I would refer to BIICL here, who says that what's written on paper is not always translated in legal practice. And I can affirm that unfortunately, That is often the case here, and that in practice there is a risk that, in particular, if a dispute is somehow political or has political dimension, then there is a higher risk that there will be issues with enforceability of a foreign arbitral award pursuant to the New York Convention. And of course, Russia is a party to the New York Convention of 1958 and should enforce foreign arbitral awards, but sometimes a public policy argument is used very broadly and arbitrary, I would say. So that remains one of the sort of major concerns. So just to wrap up, a mixed message from me. So some positive developments with more reputable international institutions being able to administer disputes on the Russian territory, which is a positive development, yet some worrying developments as to the enforceability of foreign awards and indeed ability of Russian courts to take jurisdiction over a dispute where there is parties agreement to arbitrate outside Russia. So, so this is it from me, and happy to answer any questions. Thank you.
Thank you very much, Konstantin. Very interesting presentation. I didn't know about this most recent recognition of SIAC and ICC as foreign arbitral institutions in Russia. I actually recently wrote a paper for the benefit of the Chinese Ministry of Justice, looking at how different jurisdictions approach regulation of arbitral institutions. And actually Russia was quite unusual compared to other jurisdictions. So I don't know what approach China is going to take, but now they're examining this. And I also noticed that in the chat box, there is already a live discussion about whether we should treat all CIS countries as sort of one set of countries, or they are two distinct. And I would certainly encourage you to take part in the chat discussions if you are interested. And I will also share a link to that paper on regulation of arbitral institutions in the chat box once I'm done with introducing Olena Perepelinska. Olena Perepelinska is based in Ukraine with Integrites law firm, and she is one of the most well-recognized faces of Ukrainian arbitration. Olena is also the president of the Ukrainian Arbitration Association, and she's member of the ICC International Court of Arbitration in Paris and listed as an arbitrator by a number of institutions. She works as a counsel under rules of various institutions, and she also acted as an arbitrator in about 50 arbitrations seated in different parts of the former Soviet Union region and also abroad in Paris, Stockholm, and London. Olena, very happy to have you with us today. Do you have any slides to share?
No, I don't have any slides. And first of all, I would like to thank Yarik and Dmitry for this invitation and congratulations with both anniversary and with this online event. So I would like to briefly outline what we have and what are the recent trends and draft laws, etc., in Ukraine. So very briefly, Ukraine is a model law jurisdiction. We have two different laws for domestic and for international arbitration, and our law for international arbitration is mostly a replica of the first version of the UNTITLE model law. It was slightly amended in 2017 in the course of the judicial reform, and actually the last big changes in Ukrainian arbitration-related legislation took place in the end of 2017, and those changes concerned mostly court assistance and court control functions, and actually the civil procedure rules were significantly amended, and Ukrainian Arbitration Association contributed to those amendments. Then arbitrability rules contained in commercial procedure code were changed, and some issues related to the form of arbitration agreement and some other minor issues were also changed. And actually, the written form now includes an electronic form, exchange of electronic messages as per the law. However, you should bear in mind that the civil procedure code still requires an original or a notarized copy of an arbitral agreement to be presented to the court for any setting aside an enforcement case. So this provision on electronic form does not work to the full extent. So what happened afterwards? So after the presidential elections in Ukraine, a new group about a new judicial reform was created, and Ukrainian Arbitration Association decided to offer some other amendments to that group as well. Those amendments cover some gaps identify in the legislation, both arbitration law and civil procedure and commercial procedure codes. It offers to regulate enforcement of interim measures granted by arbitral tribunals. There is an interesting history behind this initiative, because Ukraine became one of the jurisdictions actually considering the emergency arbitrators award under the New York Convention. So, and we decided that it's better to regulate it properly rather than to try to leave it as it is, and when Ukrainian courts just apply general provisions of New York Convention and Civil Procedure Code to recognize such awards. Recently, just about a bit more than a month ago, Ministry of Justice of Ukraine introduced a new draft law related to international arbitration. The draft law aims to introduce three changes. First, to regulate registration of new institutions which could administer international cases in Ukraine. Because currently we do not have any proceeding for international cases. We have the proceeding for domestic arbitral institutions, and we have like 500 plus domestic arbitration institutions administering or able to administer domestic cases. And we have basically ICAC and Maritime Arbitration Commission at the Ukrainian Chamber of Commerce and Industry as two principal institutions administering international cases. So the law aims to change that situation. The second is that law aims to delegate the functions in Article 6 of the Untitled Model Law about competent authority to appoint arbitrators and to consider challenges or termination of mandate of arbitrator to the state court. So now this function is vested to the president of the Ukrainian Chamber of Commerce and Industry to all the arbitrations seated in Ukraine. So the draft law offers to keep the president of the Ukrainian Chamber of Commerce and Industry only for the ICAC and Maritime Arbitration Commission arbitration, while for the rest of the arbitrations, it should be state courts. And last, the draft law intends to change a bit arbitrability rules, but in a quite unexpected ways, just related to corporate disputes, related to some privatization and public procurement matters, and also investor-state disputes. Interestingly enough, that in parallel, Minister of Justice or earlier, not in parallel, brought another draft law related to domestic arbitration, where it aims to reduce significantly the number of arbitral institutions by introducing some new requirements as to the registration and re-registration of existing domestic arbitration courts. So this is briefly what we have with regard to some possible amendments of legislation with regard to court practice. So Ukrainian court practice is very pro-arbitration, and tomorrow, so Ukrainian Arbitration Association has conducted research and analyzed court cases published in Ukrainian's register of court decisions. We have it public register. And for the last 15 years, and the results of that research would be presented tomorrow at the conference of the Ukrainian Arbitration Association, but I will disclose a couple of figures out of that report. It's quite interesting that the overall statistic of Ukrainian courts in arbitration-related matters is very positive. And if we look at the enforcement statistics, so in average, the successful rate on enforcement was above 80% for the last 15 years. Sometimes it was even above 90%. And last year, interestingly enough, that success rate was a bit lower because of several Russian awards. In two cases, the Ukrainian courts decided that Ukrainian sanctions regulation constitutes a part of Ukrainian public policy. And based on that, Ukrainian courts refused recognition and enforcement of two Russian CAS awards against which were rendered in favor of entity, designated entity, and which is sanctioned under Ukrainian law. So is subject to Ukrainian sanctions. It's quite interesting development because usually Ukrainian courts approach public policy in a very, very narrow way. In like 22 years ago, the Supreme Court, the old Supreme Court of Ukraine, gave a definition of public policy, and that definition was really very narrow. And Ukrainian courts try to follow that definition, and in practice, it was almost close to impossible to be successful on public policy argument before the Ukrainian court. So this change with regard to sanction policy is very interesting development. Another aspect of these two cases, not only sanctions, but a provision of Ukrainian law on private international law, which was introduced a couple of years ago. It was also related to the situation with Russia, and actually this provision allows to refuse recognition of foreign, it says decision, but it covers both judgments and awards. If they are rendered against state entities of Ukraine belonging to defense sector and having importance, strategic importance for Ukrainian state, if the enforcement is in favor of a legal entity registered in a state aggressor or a state occupier or a legal entity with a share held by such a state. So Ukrainian courts applied this provision as well and said that it's equally applicable to arbitral awards as well. A couple of other interesting negative cases which undermines in average successful statistics of Ukrainian courts concerns due notification of Ukrainian debtors, or rather undue notification. These cases also concern awards of Russian CAS, but interestingly enough, the arguments used by Ukrainian courts were borrowed from the Russian courts denying recognition of Ukrainian ICAC awards based on undue notice given to the Russian parties, because in both instances the court referred to the CIS convention and said that the notification was not done in accordance with those conventions, which of course is not correct, but the a couple of cases also followed that argumentation. But in the rest, the Ukrainian court practice is very, very pro-arbitration friendly. And as I mentioned, the success rate of enforcement is very high. With regard to setting aside of arbitral awards, the success rate, the statistics is even better. So it's close to impossible to set aside an arbitral award in Ukraine. Ukrainian ICAC publishes the statistics of setting aside of its award. As we understand, this is close to 100% of all the awards rendered in Ukraine. So in average, Ukrainian institution has about 300-400 cases, international cases per year. Out of them, it renders about 200 awards per year. And out of them, only one award in average per year is set aside. So this is even less than 1%. And in average, out of that number of awards, not more than 50 or probably 70% of all the ICAC awards are challenged at all. So probably because the parties do understand that it's not a promising exercise to try to set aside that award in Ukrainian courts. With regard to investment treaty arbitration, the last section. So as you mentioned, Yarik, Ukraine is the most popular respondent in the region. That's true. Although Ukrainian investors contributed to the statistics of other states, notably Russia recently. So Ukraine is party to ECT and over 70 BITs, and the text in all official languages of all Ukrainian BITs is available on the website of Ukrainian Arbitration Association. So we got all those texts from the archives of the Ukrainian Ministry of Foreign Affairs. It's quite a useful tool. And what is also important for Ukraine is that it paid almost all the awards against it. So I think this is also quite rare for the region. And probably with the exception of Tatneft case and related saga, Ukraine paid the awards rendered against it. I'm not sure whether it's done in all the awards rendered so far. So recently we got news that Ukraine lost another case. It was a ancestral case related to gambling ban in Ukraine, and which was brought by a casino operator against Ukraine. So it's like very recent news. However, Ukraine prevailed in many other arbitrations as well. And I think it prevailed in the majority of them. And one of the, again, recent examples, so Ukraine prevailed in an ECT arbitration under SCC rules brought by three key Cypriot companies, Litop Enterprise, Bridgemont Ventures, and Border Management for $6 billion. Ukraine, even this year, it received several new requests for arbitration or trigger letters, including in renewable sector. Other known cases are brought by Motor Sich investors, Philip Morris, etc., etc. And one more interesting aspect regarding investment treaty arbitration, that some foreign creditors, even in exit cases, follow the court proceedings to recognize and enforce the exit awards in Ukraine. I know that the convention does not suppose that it should be so, but Ukrainian foreign currency regulation is still quite peculiar and requires an enforcement writ to be presented to the servicing bank to foreign currency operations. So it's still done so, and Ukrainian courts simply refer to the civil procedural rules while doing that exercise. So just interesting. And the last cases I saw that happened was Kryvoi case and city-state case against Ukraine. So that's all. Thank you for your attention.
Thank you very much, Olena. It's good to know that there are many differences between jurisdictions, and some jurisdictions are better on one, let's say with one aspect of arbitration, let's say enforcement or paying the debts. Others are more arbitration friendly when it comes to allowing tribunals to assert jurisdiction. So I think this panel shows that there are different approaches, and perhaps different countries can learn from each other. I just looked up that Olena published her first article on the CIS Arbitration Forum 10 years ago, and the article was about new rules for interim measures related to enforcement of arbitral awards in Ukraine. So there's always something interesting happening in Ukraine. Thank you very much, Olena, for your presentation. The next speaker is Ilya Putilin. Ilya Putilin is based in Moscow, but his practice involves various jurisdictions, including Uzbekistan, which he's going to cover. He represented and advised clients in over 100 disputes before various arbitral institutions, including ACC, LCIA, ECAC, and he also sits as an arbitrator, as an expert consultant on arbitration reforms in Central and Southeast Asia. Ilya, do you have any slides to share?
No, Yarik, I don't have any slides.
Yeah, please feel free to start your presentation.
Thank you, Yarik. A very good time of the day, dear colleagues, and it is a delight to be among you today and present from the comfort of my living room. Considering that I stand between you and a networking break, I'll try to be as brief as I possibly can. Should the participants have any questions of particular interest, I'm all at your service after my presentation or during the networking break. Unfortunately, I cannot say that Uzbek arbitration scene has been that eventful in comparison to jurisdictions my fellow co-panelists have covered. What I can say, though, is that the enactment of the new International Commercial Arbitration Act earlier this year has laid a solid foundation for Uzbekistan's evolution into the regional arbitration hub. However, before I move to the Act, let me rewind a few years back to shed some light on how and when the arbitration reform started. The story begins 3 years ago when the skies were open and we had the pleasure to shake hands with fellow practitioners. In 2018, the president of Uzbekistan decreed to establish the Tashkent International Arbitration Center. In addition to creation of the TIAC, the decree lifted certain restrictions on international commercial arbitration. For example, the nationality of arbitration and the applicable law in the proceedings. The decree also envisaged that the new Act on International Commercial Arbitration shall be drafted and enacted as soon as practicable. Few words on the TIAC itself. Although created by virtue of the presidential decree, TIAC is completely independent from and is not subsidized by the government. TIAC is the first institution in the region that has a truly international board and court, which Olena and I are honored to be members of. Further, TIAC is the only institution in the world, to the best of my knowledge, that does not charge an administrative fee. In a very short time, TIAC has done an amazing job to raise awareness about alternative dispute resolution and arbitration in particular. I can see it not only in number of cases referred to TIAC, but also in number of instructions originating from Uzbek parties. And interestingly enough, those instructions are coming not only from large corporates, but also from SMEs. And that to me is an indication of growing interest and trust in arbitral process from Uzbek parties. It seems there is also a spillover effect to other areas. To read for the first time in Uzbek history, again, to the best of my knowledge, the competent authorities agreed to refer disputes arising out of national running sports competition to TIAC. So it was not the case before, and all disputes would have been referred either to CAS or to National Federation or to the state courts. And now back to the present day. On 16 February 2021, the president signed the new Act on International Commercial Arbitration that is based on ancestral model law. I had an opportunity to comment on the earlier drafts of the Act, and I must say that I'm relieved that the drafting committee decided to not reinvent the wheel and adopt the model law almost in toto. If my calculations are correct, pardon me if they are not, the Act enters into force on 17 August 2021. In other words, 6 months from the date it was published. The Act will apply to all international arbitral proceedings started after that date, regardless of the date of the arbitral agreement. Domestic arbitration proceedings would still to be governed by a standalone Act. And I'm sure that all of our participants are well aware of what the ancestral model law is. That said, rather than exploring it, I will focus on the salient changes the Act brings to the arbitration framework in Uzbekistan. First and foremost, I'd like to focus on the rights of representation. So the former Act that is still applicable to domestic arbitral proceedings said that the parties are not free to choose a representative. The current Act, based on the ancestral model law, says that they are entitled to be represented by any person of their choosing, not necessarily the member of the local bar, not even necessarily a lawyer. The second important revision that the Act brought to the Uzbek framework is the freedom to choose the applicable law in arbitral proceedings. Previously, the law that shall be applied by the arbitral tribunal in the proceedings was Uzbek law, full stop. The parties could not have agreed on any other law. Now, and in line with ancestral model law provisions, the parties are free to choose the law governing not only the arbitration clause, but applicable to the substance of the dispute. Third, choosing between two options of the right to present their case, either reasonable or full, offered by the ancestral model law, the drafters opted in for the reasonable opportunity to present their case, to present the party's case. And it makes perfect sense, you know, in the age of due process paranoia. And in a jurisdiction where the courts are not that experienced with arbitral matters, the provision as to the full opportunity to present one's case could have been easily abused. Last but not the least, the Act contains provisions on immunity of arbitrators. And that is very important considering the last Odebrecht case in Peru and the use of criminal or civil proceedings against arbitrators in other jurisdictions as guerrilla tactics to exert certain influence over the award, either during the proceedings or at the enforcement stage. Unlike Russia or Ukraine, as Olena mentioned, there is no provision in the Act, or there are no plans to introduce regulation of how the institution are to be established or how they should be operated. So this is a classic example of a model law jurisdiction. We have the framework is flexible, and the government stands aside, leaving it to the parties and NGOs to organize the arbitration regime. Is there a room for improvement? One may ask. There always is. First, there is a need for guidelines on the rights of audience in arbitration-related court proceedings. According to the presidential decree I mentioned, a party can be represented by any representative, not necessarily a member of the local bar, in set-aside proceedings related to the TX award. Although in all other arbitration-related court proceedings, there is an opportunity to apply for a so-called ad hoc admission, there is no guidelines, and the admission is solely remains or is at the judge's discretion. Second, there is no one-stop shop court that deals with set-aside applications. So you have to go through all the levels of appeal, to get the award set aside. And on that note, the language of the proceedings could be Uzbek language. Yes, there is some certain flexibility offered by the codices, procedural codices of Uzbekistan, but the default provision is that the court-related proceedings, regardless whether they are arbitration-related or not, shall be conducted in Uzbek language. And this, to a certain extent, undermines all the internationalization initiatives introduced by the Act and by the presidential decree. So let's wait and see how it develops. Third, similar to other ex-Soviet Union jurisdiction, there is a dual regulation of recognition and enforcement of foreign arbitral awards. And that means that the regulation is contained both in the Act and national procedural codices. In case of Uzbekistan, it is Economic Procedure Code and Civil Procedure Code. And the grounds for refusal of recognition and enforcement of arbitral awards are not perfectly in line. So as a logical step in the arbitration reform, and it is envisaged in the Act, that all other legislation should be made in line or harmonized or unified with the Act. To give you an example, the CPC, or the Civil Procedure Codes, rather than referring to the public policy exception, adopts the following wording, I quote, "A recognition and enforcement of an award shall be refused if it prejudices the Uzbekistan's sovereignty and or security and or against the fundamental principles of the Uzbek law." And this addition of Uzbekistan's sovereignty is quite peculiar one, in particular in the investor state setting. Fourth, now that I mentioned recognition and enforcement of awards, there is a need for training of judges on application of the New York Convention and the Act. As Baiju mentioned earlier today, any positive effect of the strong law on the paper may be nullified by its misapplication. Whether negligent or deliberate, it doesn't really matter. Although the courts are generally supportive of arbitration and do enforce awards, even against SOEs, which we all know sometimes is close to impossible in CIS jurisdictions, cases of misapplication of the New York Convention do occur, especially in the regional courts, so outside Tashkent. And I'm sure Islanbek tomorrow will add to what I've said. Fifth, the scope of notion of arbitrability shall be expanded. For example, according to the CPC, the disputes and EPC, the disputes arising out of privatization activities are not arbitrable. And considering Uzbekistan's huge plans to privatize many of the enterprises, it is a certain drawback. So I am a pro-arbitration approach evangelist, so the notion of arbitrability shall be expanded. But what about investment arbitration, one may ask? Well, the answer to this question falls back to the term recent. To me, there has not been any recent developments with Uzbek nexus on the ISDS plane. Of course, one can discuss a quite remarkable decision on jurisdiction, Baiju already mentioned, in Kim versus Uzbekistan, and the settlement that followed, or the same result achieved in Federal Electric Yeterim, but I would rather not take bread and butter away from my colleagues presenting at later stages. And on that note, I conclude. Thank you so much.
Many thanks, Ilya. And indeed, we'll go back to many of those issues which we raised as they apply in other jurisdictions. And we'll also have a chair of one of our panels tomorrow from Uzbekistan. So perhaps we could also address some questions to him. And I was involved in preparing the new Arbitration Act. Well, essentially, I was asked to review it, and I gave some feedback which was included. So I think Uzbekistan is certainly making a good progress, but there are still many things to do to make it as arbitration friendly as one would wish. So this leaves us with around 5 to 10 minutes for questions. I can already see a question in the chat box for Olena, and I'll ask Sergei to answer this question in a moment. If there are any other questions, please raise your hand now or type your question in the chat box. And I also have a question for Sargis. So my question for Sargis actually is related to international investment law. And I wonder what your thoughts are about the legality of investments in Nagorno-Karabakh, given that following these conflicts. Any thoughts on that? And let's maybe answer this question, Sargis, and then we'll have the Olena's question next.
Yeah, many thanks for this question, Yarik. The legality of investments is usually, as you know, discussed and applied when the investments are made not in accordance with the laws of the host state, for example, unclean hands and etc. However, in Armenians' case, it has a different application, i.e. whether Azerbaijan recognizes the investments made in Nagorno-Karabakh lawful or legal. Yeah, and I think the answer is in Article 29 of the Vienna Convention on the Law of the Treaties. And that article defines the territorial scope of treaties. And it says that unless a different intention appears from the treaty or is otherwise established, a treaty is binding upon each party in respect of its entire territory. I think, yeah, here we have the application of Article 29 as an answer. However, another issue, whether it is jurisdictional issue or goes to the merits, I think it's related to the scope of the tribunal's jurisdiction. And as you know, sometimes jurisdiction goes beyond the substantive protections provided by the respective treaty. Thank you.
Thank you. Oh, thank you very much, Sargis. And Sergei, would you like to ask your question using video? Or if not, then I can read it from the chat box. I think video would be preferred, Sergei. But if I do not hear from you, then okay, I will read this. Apparently there are some technical problems. So the question is to Olena, is whether in her view the Supreme Court overstretched the definition of Ukrainian public policy by refusing to enforce the Russian arbitral awards, giving effect to sanctions against the Russian claimants.
Thank you, Sergei, for question. So with regard to this case, I should give a bit more details for our audience to understand better what happened. So there were 3 quite similar cases between the same parties with 3 different awards rendered by Russian cause. And these 3 awards were then submitted by the Russian creditor before the Ukrainian courts. And the outcome of these 3 cases is different. And this is, I think, the trick here. So in 2 cases, in 2 later cases, as I mentioned, the enforcement was refused based basically on 2 grounds. First is public policy, involving the sanction policy of Ukraine, and second, this special provision of the law of Ukraine and private international law. In the first and earlier case, again, more or less the same subject matter, so it's also defense and military and defense production, the same parties. Ukrainian courts decided that it should not refuse enforcement. Basically, it considered that the sanctions it considered which type of sanctions applied in this particular situation, and that sanction indeed covered ban to disposing some assets of the designated entity. However, the court decided that it's not the matter of recognition and enforcement. It's a matter of state bailiff to decide whether to and how to apply that particular sanction in a particular situation. And here is an interesting theoretical and practical issue. Whether it's indeed something to be policed by the bailiff when it has an enforcement rate, or it's something to be done by the Ukrainian courts. From political perspective, sanctions, I would think that most of the country would consider sanctions as a part of public policy. The difference of these cases is that the Ukrainian traditional notion of public policy would probably not cover sanctions if read literally. And in this particular situation, I think it was important first to explain the different approach and actually the same situation. So I think what Ukrainian court have not done is to explain whether they departed from the initial approach. And second, I think that this particular provision of the law of Ukrainian private international law was also important because it gave a separate ground for refusal to recognize and enforce the arbitral award. So I hope I have answered to your question. Thank you.
Many thanks, Olena. And we will have a whole panel dealing with sanctions tomorrow. That's the last panel of the sanction. The last panel of the conference will be dealing with sanctions. I was actually trying to get someone from the UK government to talk about sanctions from their perspective. I couldn't get anyone. Tomorrow we'll have a speaker from the Russian Ministry of Justice, but I think her focus will not be on sanctions, but on enforcement of judgments. So let me thank all the speakers for their excellent presentations. Now, certainly we know more about the hottest topics in Russia, in Ukraine, in Armenia, in Uzbekistan, and in Kazakhstan. And I look forward to seeing you later during the conference with your questions and comments. And now we have a networking break, 15 minutes. So feel free to use the chat box for networking. Unfortunately, in the COVID times, that's the only thing we have. And also, I would encourage you to join the LinkedIn group of the CIS Arbitration Forum, and also to connect with those who are attending this conference today using LinkedIn and other social networks. So I will see you in 15 minutes. Feel free to use the chat box now or even to speak using voice, completely up to you, but we will restart in slightly less than 15 minutes.